And we are live streaming on YouTube, just so everybody knows now. Are we all set, Attorney Ciccone, to call the case?
Yes, Your Honor. Thank you.
Can we see your client?
Sure.
Okay, great. Thank you. This is Brown County case number 20 CT 1140, State of Wisconsin versus Ruben Leonardo Saez Irizarry.
Este es el caso del Condado Brown, Estado de Wisconsin, contra Rubén Saez Irizarry, 27-1140.
The state is here by Assistant District Attorney Aaron Linson.
El Estado está aquí, el subfiscal Aaron Linson.
Attorney Jevin Ciccone is appearing by video with his client, Mr. Saez Irizarry.
El licenciado Jevin Ciccone comparece por video con su cliente, el señor Saez Irizarry.
We are doing the hearing by video conference because of a global, national, and local public health emergency.
Estamos haciendo la audiencia por videoconferencia debido a una emergencia global, nacional y local de la salud pública.
We are live streaming on YouTube, and there is no one in the courtroom gallery.
Estamos transmitiéndola en vivo por YouTube y no hay nadie en los asientos públicos de la sala de justicia.
We also have certified Spanish interpreter Sarah Fascheski. Have you been sworn today?
No, Your Honor.
If you could please raise your right hand. Do you swear to tell the truth? I'm going to back up. Do you swear to interpret Spanish into English and English into Spanish to the best of your ability, so help you God?
I do, Your Honor. Y tenemos la intérprete certificada de español, Sarah Fascheski. El juez preguntó si había sido juramentada hoy. Contesté que no y me puso bajo juramento para que yo jurara interpretar correctamente lo mejor que pueda.
Attorney Ciccone, what is our status here today?
Licenciado Ciccone, ¿cuál es el estado de esto hoy?
Yes, Your Honor. There was a plea questionnaire filed, it appears a little bit ago. I do have the missing parts here with the defendant.
Sí, su señoría, se presentó al parecer hace poco el cuestionario declaratorio. Aquí tengo las partes que faltan aquí con el acusado.
It is getting processed right now. Can we get a mailing address for your client?
Lo estamos procesando ahora mismo. Nos da una dirección para el correo de su cliente.
Sure, I'll get it imminently.
Sí, voy a conseguirla inminentemente.
Okay. Be 1495 Shawano Avenue. The zip is 54303.
Ok, es el 1495 de la avenida Shawano y el código postal es 54303.
Is there an apartment number or not?
¿Hay un número de apartamento o no?
House.
Es casa.
According to the plea form, the plea will be no contest to count 1, OWI second, and count 2, hit and run. Is that correct?
Actually, sorry, you go first.
Según el formulario de la declaración va a ser que no se opone al primer cargo, segunda ofensa de operar en estado de ebriedad y al segundo cargo, chocar y fugar.
Actually, it looks like counts 1 and 3 should be.
La verdad parece que deben de ser los cargos 1 y 3.
That modification will be noted.
Se notará esa modificación.
I assume count 2 will be dismissed. That's the PAC count. What about the other hit and run count 4?
Supongo que el segundo cargo se desestimará, es el cargo por CAS, pero el otro cargo número 4, por el otro por chocar y fugar.
Count 4 will be dismissed and read in.
El cuarto cargo se desestimará y se leerá.
Is the state in compliance with victim notification?
¿Está en cumplimiento el Estado con la notificación de víctimas?
We are.
Sí.
And Attorney Giacone, it looks like you reviewed the plea form in person with your client.
Y licenciado Giaconi parece que revisó el cuestionario declaratorio con su cliente en persona.
With the assistance of my paralegal translator.
Con la ayuda de mi traductora, mi auxiliar de abogado.
And did you talk about the video conference appearance?
¿Y se hablaron sobre una comparecencia por video?
Yes, he had no objection.
Sí, él no quería oponerse.
If I can talk to Mr. Saez Irizarry now.
Sure, what we'll do is
Déjame
change
hablar ahora
places.
con el señor Saez Irizarry. Sí, cómo no.
Are you able to see me and hear me clearly?
¿Me ve y me oye claramente?
Sí.
Yes.
And I am able to see you and hear you clearly as well.
Y también lo oigo y lo veo claramente.
You do have a right to be present in person in the courtroom. We're doing the hearing by video conference because of the public health emergency.
Sí tiene derecho a estar presente en la sala de justicia en persona. Estamos haciendo la audiencia por videoconferencia por la emergencia de la salud pública.
Are you willing to waive your right to be present in person so we can continue with this video conference?
¿Está dispuesto a renunciar a su derecho a estar presente en persona para que podamos proceder con esta videoconferencia?
No, no tengo problema.
No, I've got no problem with it.
If you need to speak with your lawyer privately at some point, it is as simple as muting your device.
Si en algún momento necesita hablar con su abogado en privado, es tan sencillo como poner el mute.
If you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law.
Si no es ciudadano de los Estados Unidos de América, se le avisa que si presenta una declaración de culpable o no me opongo ante los delitos imputados, podría resultar en su deportación, exclusión de ingreso a este país o denegación de la nacionalización bajo ley federal.
Do you understand?
¿Entiende?
Sí, entiendo.
Yes, I understand.
According to the plea form, you are 47 years old. Is that correct?
Según el cuestionario declaratorio, usted tiene 47 años de edad, ¿es así?
Sí, es correcto.
Yes, that's correct.
Do you have a high school degree or an equivalency degree?
¿Tiene usted el diploma de la preparatoria o algún equivalente?
Lo tengo, pero no lo tengo encima ahora mismo.
I do have it, but I don't have it on me right now.
But you do have a high school degree?
Pero sí tiene su diploma de la preparatoria.
Sí, lo terminé el GDL en Puerto Rico.
Yes, I finished my GED in Puerto Rico.
Are you able to read and write any English?
¿Puede leer o escribir algo de inglés?
Sí,
Yeah.
And are you able to read and write Spanish?
¿Y lee y escribe el español?
sí,
Yes.
Have you been able to understand the interpreter so far?
¿Hasta ahora ha podido entender a la intérprete?
sí, muy bien.
Yes, very well.
Are you currently receiving treatment for mental illness or disorder?
¿Actualmente está recibiendo tratamiento por una enfermedad o trastorno mental?
No,
No.
Have you had any alcohol, medications, or other drugs in the last 24 hours?
¿Ha tomado usted el alcohol, cualquier medicamento o cualquier otra droga en las últimas 24 horas?
no,
No.
The charge in count 1 is misdemeanor operating a motor vehicle while under the influence, second offense.
El cargo 1 es un delito menor por haber operado un vehículo motorizado en estado de ebriedad, la segunda ofensa.
The maximum penalty is 6 months jail or a $1,100 fine or both.
La pena máxima es 6 meses de cárcel o una multa de $1,100 o ambas cosas.
Do you understand that is the maximum penalty?
¿Entiende usted que esa es la pena máxima?
sí, entiendo.
Yes, I understand.
There's also a minimum penalty of 5 days jail and a $350 fine. Do you understand?
También hay una pena mínima de 5 días en la cárcel y $350 de multa. ¿Entiende?
Sí,
Yes.
There is also a driver's license revocation between 1 year and 18 months that is required. Do you understand?
También hay un requisito de que se le tiene que revocar la licencia para manejar por al menos un año hasta 18 meses. Es un requisito, ¿entiende?
sí, entiendo.
Yes, I understand.
The ignition interlock device will also be required. Do you understand?
También tendrá como requisito el dispositivo para tener el encendido, ¿entiende?
Sí,
Yes.
The elements of operating while intoxicated are first, that you operated a motor vehicle on a highway. Second, at the time of the operation, you were under the influence of an intoxicant. You understand those are the elements.
Los elementos de operar en estado de ebriedad son el primero, que usted operó un vehículo motorizado en una carretera, y el segundo, que en el momento de esa operación estaba bajo los efectos de alguna bebida embriagante. ¿Entiende los elementos?
sí,
Yes.
The state believes you have one prior conviction for operating while intoxicated from October 6th, 2010, with an offense date on August 26th, 2010.
El Estado cree que usted tiene una condena previa por haber operado en estado de ebriedad de la fecha del 6 de octubre de 2010 y la fecha de la ofensa es el 26 de agosto 2010.
Do you agree that is one prior conviction for operating while intoxicated?
¿Está usted de acuerdo que hay una condena previa por operar en estado de ebriedad?
Pero ya yo había cumplido eso en esos años.
But I had already finished all that during that time in those years.
You did, but I need you to acknowledge that you have one prior conviction.
Sí, usted sí lo hizo, pero necesito que me confirme que sí tiene esa condena previa.
Sí,
Yes.
And you understand that prior conviction makes this a second offense.
Y entiende usted que por tener esa condena previa hace que esta sea la segunda ofensa.
sí, es correcto, sí.
Yes, that's correct. Yes.
Count 3 is misdemeanor hit and run of an attended vehicle.
El tercer cargo es un delito menor por chocar un vehículo con ocupantes y fugar.
The maximum penalty is 6 months jail or a $1,000 fine or both. Do you understand?
La pena máxima es 6 meses de cárcel, una multa de $1,000 o ambas cosas. ¿Entiende?
Sí,
Yes.
There is also a mandatory minimum penalty of a $300 fine. Do you understand?
También hay una pena mínima obligatoria, una multa de $300. ¿Entiende?
sí,
Yes.
The elements of hit and run of an attended vehicle are first, that you operated a vehicle involved in an accident on a highway.
Los elementos de chocar un vehículo con ocupantes y fugar son el primero, que operó un vehículo que estuvo envuelto en un accidente en una carretera.
Second, you knew the vehicle you were operating was involved in an accident with an attended vehicle.
El segundo, que usted sabía que el vehículo que operaba y que estuvo envuelto en un accidente fue un accidente con un vehículo con ocupantes.
Third, the accident resulted in damage to a vehicle.
El tercero, que el accidente resultó en algún daño al vehículo.
Fourth, you did not immediately stop your vehicle at the scene of the accident and remain at the scene.
El cuarto, que usted no detuvo inmediatamente su vehículo en el lugar del accidente y tampoco se quedó en el lugar del accidente.
Fifth, you were physically capable of complying with this requirement.
El quinto, que usted tenía la capacidad física de haber podido cumplir con ese requisito.
Do you understand those are the elements of hit and run of an attended vehicle?
¿Entiende usted que aquellos son los elementos de chocar un vehículo con ocupantes y fugar?
sí,
Yes.
The criminal complaint outlines the facts that the state believes are true. Do you agree there are enough facts in the criminal complaint to support your plea to each charge?
La denuncia penal resume unos hechos los cuales cree el Estado son ciertos. ¿Está usted de acuerdo que hay suficientes hechos en la denuncia penal para fundamentar su declaración de cada cargo?
sí,
Yes.
I have reviewed the criminal complaint and I will find there is a sufficient factual basis for the plea.
He revisado la denuncia penal y determino que hay un fundamento adecuado en los hechos para la declaración.
Do you understand? I don't have to go along with any recommendation, and I could sentence you up to the maximum penalty.
¿Entiende usted que no tengo que seguir ninguna recomendación y que podría sentenciarlo con hasta la pena máxima?
Yeah, sí.
Yes, yeah, yes.
You have the following constitutional rights: the right to a jury trial, where all 12 jurors would have to agree that you're either guilty or not guilty.
Usted tiene los siguientes derechos constitucionales: el derecho a un juicio con jurado, en el cual los 12 jurados todos tendrían que ponerse de acuerdo que si usted es culpable o no culpable.
Your right to remain silent, your right to testify and present evidence,
Su derecho a permanecer en silencio, su derecho a dar testimonio y presentar pruebas,
your right to use subpoenas, and your right to cross-examine witnesses,
su derecho a usar citaciones judiciales y su derecho a contrainterrogar a los testigos.
and a right to make the state prove that you're guilty beyond a reasonable doubt.
Y el derecho a obligar que el Estado pruebe su culpabilidad más allá de cualquier duda razonable.
Do you understand that you'd be giving up those rights by entering a no contest plea?
¿Entiende usted que estará cediendo esos derechos si presenta una declaración de no me opongo?
Sí.
Yes.
Are you making the no contest plea of your own free will?
Está presentando esta declaración de no me opongo por su libre voluntad.
Sí.
Yes.
Has anybody put any pressure on you or forced you to make a plea?
¿Le ha puesto alguna persona presión o lo ha forzado a presentar una declaración?
No.
No.
Do you have any questions about anything that we've talked about?
¿Tiene alguna pregunta sobre cualquier cosa que hemos hablado?
No. No para el momento.
No, not at the moment.
Have you had any issues with the interpreter?
¿Ha tenido cualquier problema con la intérprete?
No.
No.
And have you had sufficient time to review this case with your lawyer?
¿Y ha tenido suficiente tiempo para revisar este caso con su abogado?
Sí.
Yes.
Attorney Giacone, are you satisfied your client is freely, voluntarily, intelligently, and knowingly making this plea?
Licenciado Giaconi, ¿está convencido que su cliente presenta esta declaración de manera voluntaria, inteligente y a sabiendas?
Yes,
Sí.
Are you satisfied he understands the elements, the facts, and the rights he is giving up?
¿Está convencido de que él entiende los elementos, los hechos y los derechos que está cediendo?
yes, my apologies for not adding them on the plea form. I can add a supplement and we did go over them as well. Thank you.
Sí, y pido disculpas por no haber agregado eso al cuestionario declaratorio. Puedo añadir un anexo y sí los revisamos. Gracias.
If I could go back to Mr. Saez Irizarry again, are you prepared to make a plea at this time?
Si me permite hablar otra vez con el señor Saez Irizarry, ¿está preparado a seguir adelante ahora y presentar una declaración?
Yeah, sí.
Yes.
As to count 1, misdemeanor, operating a motor vehicle while under the influence, second offense, what is your plea?
Del primer cargo, el delito menor de operar un vehículo motorizado en estado de ebriedad como segunda ofensa, ¿cómo se declara?
No lo contesté. No contaste.
No contest.
As to count 3, misdemeanor hit and run of an attended vehicle, what is your plea?
Del tercer cargo, el delito menor de chocar un vehículo con ocupantes y fugar, ¿cómo se declara?
Sí.
Yep.
No contaste.
No contest.
I will accept the no contest plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made.
Acepto la declaración de que no se opone, determino que la ha hecho de manera voluntaria e inteligente a sabiendas.
I will find that he understands the elements, the facts, and the rights that he is giving up.
Determino que él sí entiende los elementos, los hechos y los derechos que cede.
I'll find him guilty of the 2 offenses and order judgment of conviction entered into the record.
Lo hallo culpable de los 2 delitos y ordeno que se registre en el acta el fallo de su condena.
Count 2 will be dismissed. Count 3 dismissed and read in.
Quedará desestimado el segundo cargo y el tercer cargo se desestima y se lee.
I meant count 4 will be dismissed and read in.
Yeah.
Quise decir que se lee y se desestime el cuarto cargo.
And then as to sentencing from the state,
Ahora, en cuanto a la sentencia, diga Estado.
Your Honor, this is a second offense OWI that involved sideswiping 2 vehicles and crashing into a light post.
Su señoría, esta es segunda ofensa de operar en estado de ebriedad y un incidente que involucraba un choque lateral de 2 vehículos y después un choque con un poste.
There was a subsequent refusal on the blood draw and a 0.137 blood alcohol content.
Subsecuentemente rechazó la muestra de sangre y salió la concentración sanguínea de alcohol en 0.137.
As such, the state is recommending a 12-month period of probation.
Siendo así, el Estado recomienda un periodo de 12 meses de libertad probatoria.
The conditions of probation on count 1 to include 30 days jail,
Las condiciones de la libertad probatoria con respecto al primer cargo incluirán 30 días de cárcel,
a $500 fine plus costs totaling $1,618,
una multa de $500 más costos que equivale a un total de $1,618,
a 14-month revocation of the driver's license,
una revocación de su licencia para manejar durante 14 meses,
a 14-month period of the ignition interlock device,
el requisito del dispositivo en el encendido por un periodo de 14 meses,
AODA,
la evaluación a ODA,
and a $46.50 blood draw fee,
y un costo de $46.50 por la muestra de sangre.
those conditions would be consistent with a sentence under the right-sided guidelines for the 0.137 BAC.
Esas condiciones van de acuerdo con una sentencia que está conforme con las normas derechas correspondientes a un nivel sanguíneo de 0.137.
On count 3, the conditions include a $300 fine plus costs,
Por el tercer cargo, las condiciones incluirán una multa de $300 más costos.
On both counts, we would be requesting payment of restitution if claimed.
Por ambos cargos, pedimos que se le ponga el requisito de pagar restitución si se solicitara.
The state would not impose early termination upon completion of the conditions of probation.
El Estado no se opone a que se le dé de alta temprano si ha completado las condiciones de su libertad probatoria,
Including the payment of the restitution.
incluyendo el pago de la restitución.
At this time, one of the two victims has indicated they are not seeking restitution. I do not have clarifying information from the other victim.
Ahora mismo, una de las dos víctimas ha avisado que no va a estar pidiendo restitución y no tengo información a modo de una aclaración por parte de la otra víctima.
Attorney Giacone?
Licenciado Giacone.
Yes, Your Honor. I think we might have a quick question. My understanding, is there any way I can do a breakout session with Attorney Linson real quick?
Sí, señoría. Yo tengo rapidito una pregunta. ¿Sería posible que nos pase a una sala privada, yo y el señor Linson?
I created the breakout room, so just accept the prompt. And the attorneys and Mr. Saez Irizarry are in the breakout room. So we're off the record until they return. And then for everybody else that is on this Zoom video call, right now we're doing the only case that was scheduled for 1:30, and then we'll start calling the 2 o'clock cases. There's 5 cases at 2 o'clock. While we're waiting, the 2 o'clock cases are Robert Laughlin, Jamie Metoxen, Christopher Oatman, Donald Oden, Nathaniel Robinson. Attorney Zawada, it looks like you have 2 of them. Are we doing anything other than scheduling on each one?
Nathaniel Robinson will be a plea sentencing.
Okay. And then Oden will just be a request for rescheduling?
Yes.
Okay. And then Attorney Stock, what are we planning on doing on your case?
I just got one of the 3 files, Your Honor, for my cases, so I'm going to probably be rescheduling.
Okay. And
Yeah, I
we
just
can't
one.
we can't do the reschedules yet because the prosecutor's in the breakout room. Otherwise, we would move along to that.
Yeah, I don't see my client in the Zoom anyways.
Okay. Why don't you give him a call right now then?
Yeah, is there anybody in the courtroom, Your Honor?
There is, but they're all accounted for, and it's not your client.
Okay, just checking. Thanks.
And then Robert Laughlin, it looks like you don't have a lawyer on your case yet, but we'll call your case momentarily. So please just stand by. If you could please mute your devices until the case is called. So your case is called. I'm going to mute the one that I think I hear background noise from. Okay, I think that took care of it. Okay, we're back on the record in Saez Irizarry. All parties are present again.
Ok, nuevamente estamos haciendo constar en este acta el caso de Saez Irizarry. Todas las partes están presentes otra vez.
Attorney Giaconi, I think I was going to you next for your sentencing argument.
Actually,
Señor Giaconi, creo que me dirigí a usted después para que diga su recomendación de sentencia.
Your Honor, actually,
yeah.
after discussions with Attorney Giaconi, I'd like to make a slight alteration to my recommendation to be more in line with the defendant's understanding of the plea offer.
Su señoría, la verdad, después de mi conversación con el señor Giaconi, quisiera hacer una leve modificación a mi recomendación de sentencia para estar más de acuerdo con la comprensión del acusado de su convenio declaratorio.
I would withdraw the state's request for probation and ask those conditions be assessed as a straight sentence.
Retiro mi petición por parte del Estado para la libertad probatoria. Quisiera pedir que esas condiciones se incluyan en una sentencia sencilla.
Which would be the right-sided guidelines for the charge. And then on count 3, a $300 fine plus costs and restitution. I would ask that restitution be held open for 30 days.
Y eso está de acuerdo con las normas derechas en cuanto a este cargo. Y por el tercer cargo, una multa de $300 más costos y también la restitución. Pido que se deje pendiente la restitución por 30 días.
I would just note that the victim was notified of this hearing back in November, and as of today's date, we have not received a restitution form back.
Solo quisiera destacar que fue notificada la víctima de lo de hoy en noviembre y hasta la fecha no hemos recibido ningún formulario de restitución.
Attorney Giaconi?
Yes, Your Honor. Yes, Your Honor. That would essentially be a joint recommendation. We would actually, the only difference, we would ask for 25 days jail. The defendant's last OWI was in 2010. He's working full-time, has been a good citizen since then. I don't see anything else on his record. And it doesn't look like there's any credit. So that's what we would recommend. Oh,
Now let the interpreter interpret.
okay.
Sí, su señoría. Y en efecto va a ser una recomendación conjunta. La verdad, solo quisiéramos cambiar algo poquito. Pediremos 25 días de cárcel. La última ofensa de operar en estado de ebriedad de este acusado fue en el 2010. Desde entonces ha tenido trabajo de tiempo completo, ha sido un buen ciudadano y por lo que miro aquí realmente no tiene antecedentes y parece que no tiene ningún abono de crédito.
Mr. Saez Irizarry, now is your opportunity to address the court if you choose to do so.
Y deje que la interprete. Ok, señor Saez Irizarry, ahora tiene su oportunidad de dirigirse al tribunal si desea hacerlo.
He's fine. Está bien, lo lamento lo que pasó, pero pues yo sé que me merezco una oportunidad y que me disculpen y no va a volver a pasar, sinceramente.
Well, I lament what happened, but I know I deserve a chance, and I am sorry for it, and it will not happen again, I say sincerely.
Thank you.
Gracias.
When I issue a sentence, I have to consider protection of the public, gravity of the offense, rehabilitative needs of the defendant, character of the defendant, and deterrence of others.
Cuando quiera que yo dicto una sentencia, tengo que tomar en cuenta la protección del público, la gravedad del delito, las necesidades del acusado para una rehabilitación, el carácter del acusado y la disuasión de los demás.
Then apply the Gallian sentencing factors to those objectives.
Y luego debo aplicar los factores de sentencia Gallion a esa meta de sentencia.
Mr. Saez Irizarry's record appears to be limited to the prior OWI offense.
Los antecedentes del señor Saez Irizarry parecen estar limitados a la ofensa previa de operar en estado de ebriedad.
So he is probably someone that would never intentionally hurt anybody. But in this case, he could have caused somebody to have a very violent death.
Así que probablemente es una persona que nunca le haría daño a nadie intencionalmente, pero en este caso sus acciones podrían haber provocado una muerte violenta.
Because he was operating a vehicle weighing thousands of pounds while intoxicated.
Porque operaba un vehículo que pesaba miles de libras mientras estaba en estado de ebriedad.
When vehicles weighing thousands of pounds collide with each other, it's the human beings inside that absorb the force.
Cuando los vehículos que pesan miles de libras se colisionan, son los seres humanos que están adentro quienes absorben ese impacto.
And call it luck or divine intervention, fortunately, nobody suffered any serious injuries in this case.
Y dígale que es la suerte o la intervención divina, pero afortunadamente en este caso nadie sostuvo lesiones graves.
But this case really is the exact case that parents in the community fear, have driving their children around or when their children are old enough to drive themselves.
Pero este caso en sí es el caso ejemplar, el exacto que los padres temen en la comunidad cuando transportan a sus niños o cuando sus niños crecen a suficiente edad para que ellos mismos manejen.
The guidelines factors do go back and forth between mitigating and aggravating.
Con respecto a los factores de las normas, hay factores mitigantes y agravantes que están presentes aquí.
The prior OWI was a long time ago. Mr. Saez Irizarry is 47 years old with no other criminal record.
La última ofensa de operar en estado de ebriedad sucedió hace mucho tiempo y el señor Saez Irizarry tiene 47 años de edad y parece que no tiene otros antecedentes penales.
He's taken responsibility for the offense by entering a no contest plea.
Se ha responsabilizado por el delito, del delito, presentando una declaración de no me opongo.
The BAC is basically in the middle of the guidelines tier.
La concentración sanguínea básicamente cae en medio del rango expresado en las normas.
His appearance that's described in the criminal complaint is someone who's very intoxicated.
Y su aspecto que se describió en la denuncia penal era de una persona demasiado ebria.
And but the overwhelming factor between mitigating and aggravating factors is the accident that was caused.
Pero el factor que toma prioridad al contemplar los mitigantes y los agravantes es el accidente que resultó.
So the sentence on count 1 will be 30 days jail with Huber and good time.
Entonces, la sentencia con respecto al primer cargo será 30 días de cárcel con el privilegio Huber y reducción del tiempo por buen comportamiento.
A $500 fine for a total of $1,618. $14 months revocation of driver's license, 14 months of the ignition interlock device.
Your Honor, the interpreter had a slight blip here. Did you say that for a total of 1618?
Yes.
La intérprete perdió señal por un segundo, pero aclaró lo que faltó. Una multa de $500 con los costos que equivale $1,618, una revocación de la licencia para manejar durante 14 meses y el uso del dispositivo en el encendido por 14 meses.
An AODA assessment, $46.50 for the blood draw fee.
Una evaluación a ODA y un costo de $46.50 por la muestra de sangre.
On count 3, the $300 mandatory fine plus court costs.
Por el tercer cargo, la multa mandatoria de $300 más costos.
The total is $851.
El total es $851.
He has 30 days to pay the $46.50 for the blood draw fee.
Cuenta con un plazo de 30 días en el cual puede pagar la cuota por la muestra de sangre, $46.50.
The remaining financial penalties, he'll have 6 months to pay or set up a payment plan.
Con respecto al resto de las penas financieras, tendrá un plazo de 6 meses para pagar o para hacer un plan de pagos.
And then for a report date within 60 days.
Y luego una fecha para que se presente a la cárcel dentro de 60 días.
You want to put February 26th? He does have his Huber and EMP stuff filled out already.
Quiere ponerle el 26 de febrero. Ya ha completado el papeleo para el Huber y EMP.
Then report February 26th.
Entonces, que se presente ahí el 26 de febrero.
Is there any jail credit?
¿Hay abonos de crédito de tiempo en la cárcel?
Not that I saw, Your Honor.
No que yo haya visto, señoría.
Then no credit will be on the judgment of conviction. Also, 30 days for any victim to submit restitution for consideration.
Entonces, no se incluirá ningún abono de crédito en el fallo de la condena y también un plazo de 30 días en el cual cualquier víctima podrá presentar una petición de restitución para consideración.
Anything additional from the state?
¿Algo más por parte del Estado?
No, Your Honor, sorry.
No, su señoría, disculpe.
Attorney Giacone, if you could review the post-conviction rights with your client, is there anything else from your end?
Licenciado Giacone, por favor, que revise con su cliente los derechos que tiene después de la condena. ¿Hay algo más de su punto de vista?
No, Your Honor, and will do.
No, su señoría, y así lo haré.
Then that's the sentence of the court, and that's all for today in this case.
Entonces esa es la sentencia del tribunal y es todo por hoy en este caso.
Thank you, Sarah. I think that's the only case for you.
I have a 2:30. Is that a different meeting?
It should be the same meeting ID for all afternoon.
Oh, okay, yep. So I'll just go silent here.
Okay, thank you. We do have a case that's in the courtroom. Why don't we call that one first? That is Christopher Oatman. Attorney Herman already said he just wants to schedule it for trial, so it should be pretty quick. This is Brown County case number 19 CM 1553, State of Wisconsin versus Christopher James Oatman. The state is here by video conference with Assistant District Attorney Aaron Linson. Attorney John Herman and his client, Mr. Oatman, are appearing in the courtroom. Attorney Herman, what's our status here today?
Here at this time, we're going to be requesting that jury trial on the center.
The jury trial date will be Wednesday, April 21st. The jury selection will be Tuesday, April 20th at 1:30. And then we'll schedule a final conference for Monday, April 5th at 1:30.
That works for me.
ADA Linson, did you get all the dates?
I did.
And Mr. Oatman, did you hear all the dates? Thank you. Yeah, the final conference date will be in person. Your client is requesting in-person hearings?
Yes. That's
Okay.
right.
And then bond continue, and that's all for today on this case. Thank you.
Thank you.
Attorney Stack, why don't we call your case?
All right.
Jamie Metaxen. Jamie Metaxen. Jamie Metaxen. This is Brown County case numbers 20 CM 592, 20 CM 1370, 20 CM 1468. State of Wisconsin versus Jamie Lynn Metaxen. The state is here by Assistant District Attorney Aaron Linson. Attorney Matthew Stock is appearing. Ms. Metaxen does not appear. We're doing the hearing by video conference because of the public health emergency. We are live streaming on YouTube. There is no one in the courtroom gallery. The courthouse is open to the public, so Ms. Metaxen would be able to walk into the courtroom, and she is not present in the courtroom. She's not present on the video conference. Attorney Stock, have you had any recent contact?
I just got appointed on her third file here. I have no additional information as to her whereabouts.
ADA Linson, any additional comment?
No, Your Honor, at this time, the state would request a bench warrant. She's had multiple missed appearances in the past.
Then I am going to issue a bench warrant forthwith then. And then that's all on this case. Thank you.
Is that available to take up in CCA or branch 8 only?
CCA.
Okay, thank you.
Yep. And then I know Attorney Zawada, you said one of your cases was going to be a police. We're actually going to go to Mr. Laughlin, Robert Laughlin. And then
That's okay, thanks.
Then we'll go to Attorney Zawada's cases. This is Brown County case number 20 CM 1209, State of Wisconsin versus Robert Joseph Laughlin. This is here by Assistant District Attorney Aaron Linson. Mr. Laughlin is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. I believe at the last hearing, Mr. Laughlin was going to go to the public defender's office to see if he qualifies for their representation. Were you able to do that, Mr. Laughlin?
Your Honor, that was actually, that possibility was 2 hearings ago. In the last hearing, I went through all of the language and official things that needed to be gone through and repeated and agreed to by me to go without representation, to represent myself, Your Honor.
Okay. When was the last time we had court? Or last time was November 30th. Okay. 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 It looks like I have talked to you about your options for getting a lawyer. And is it your decision to continue to represent yourself here today?
Yes, Your Honor.
Okay. ADA Linson, has there been any contact with Mr. Laughlin?
From our office, no, the last note I have is that he may want counsel as of the last hearing in November.
I have a minute sheet in front of the court commissioner from October 29th. It does have it checked out that he was advised of his right to counsel.
That's what I have as well.
He did waive his right to counsel in front of the court commissioner. And then he was in front of me November 30th. And then I think I explained the public defender's office option to Mr. Laughlin. And if I recall correctly, he was going to go there, but he might not go there. And it sounds like he decided not to go there. So Mr. Laughlin, you want to represent yourself? I'll ask you one more
Yes, Your
time.
Honor.
Okay.
Yes.
Did you want to contact the district attorney's office directly then to see how they want to resolve the case?
I would like to do that, Your Honor. If I had known that was, I'm not too familiar with court proceedings and what have you. If I had known that been an option, I apologize. I would have done so weeks ago. But yes, I would like that opportunity, Your Honor, if possible.
The record shows that his options for lawyers have been explained at least 2 times. And I'll find that he is knowing and voluntarily waiving his right to an attorney and wants to proceed pro se. You can change your mind at any point and hire a lawyer if you want. You do have to notify the DA's office and the court if you decide to hire somebody. The DA's office phone number is 448-4190. The prosecutor assigned to your case is Miranda Hillman, Hillmann. So you'd have to call that number, the main office number, to set up an appointment with her.
All right, Your Honor. Thank you very much.
The next court date will be Tuesday, March 9th at 9 o'clock.
Roger that, Your Honor. And is that 100% set in stone, or is there any way that after my conversation or conversations with Ms. Hillman, we might be able to get things wrapped up a little bit sooner than that? Or is this March 9th court date happening regardless?
That March 9th date is going to be pretty firm just because the calendar is so full. I'm really giving you the first date I have available.
Roger that, Your Honor. Thank you.
Tuesday, March 9th at 9 o'clock. Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all today. Thank you.
Thank you, Your Honor.
And then Attorney Zawada. Donald Oden.
Come on, how do I?
This is Brown County case number 20 CM 625, State of Wisconsin versus Donald Cornelius Oden. The state is hereby Assistant District Attorney Aaron Linson. Attorney Brianna Zawada is present. Mr. Oden does not appear. He does not appear on the video conference, and he's also not in the courtroom. The building is open to the public, so he would be able to walk in here unrestricted. We're doing the hearing by video conference because of the public health emergency. Attorney Zawada, have you had recent contact with your client?
Your Honor, not recent contact. I'm looking at the CCAP listing for this case. I don't believe Mr. Oden has had an issue. No, I apologize. There was one return on warrant with this case here, but additionally, he did recently get back into compliance with CJS, and I called CJS today. I know they said that he had his check-in on, I believe it was the 18th, they said. So within a week, he did a check-in with CJS. So, you know, I would note that he hasn't gone AWOL. He has been in contact with the criminal justice system here through CJS. So I'm asking that you consider either rescheduling or staying the warrant for a period of time in the event Mr. Oden gets in touch with me.
Attorney ADA Linson.
Your Honor, my concern is that this would be the third missed appearance since June. I believe one of them may have been tied to Attorney Abhi Samra's departure from the public defender's office, but it is the third time Mr. Oden has missed court. I do note he is in compliance with criminal justice services, but for a while was not. I think at this point, I would request a bench warrant.
I'll authorize a bench warrant noon on Friday, just because then I'm staying it solely because it looks like he is probably in compliance with CJS right now. But if he's not brought into CCA before noon on Friday, the warrant will issue.
Okay, thank you.
Thank you.
And then 20 CF 707, State of Wisconsin versus Nathaniel James Robinson. The state is here by Assistant District Attorney Aaron Linson. Attorney Brianna Zawada is present. Mr. Robinson is appearing by video from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Zawada, what is our status here today?
Your Honor, we are ready to resolve. I did previously e-file the plea questionnaire waiver of rights in this case, as well as the jury instructions for possession of drug paraphernalia and possession of a controlled substance.
So the plan would be to plead no contest to both charges effectively?
That's right.
Is that the state's understanding?
That is my understanding, Your Honor.
And Mr. Robinson, is that your intent to plead no contest to both counts?
Yes.
Attorney Zawada, did you talk about the video conference appearance with your client?
Your Honor, I have in the past, it's my understanding that Mr. Robinson would like to appear for this appearance by Zoom video conference. Is that right, Mr. Robinson?
Yes.
Okay, so you do have a right to be present in person. You're willing to waive that right so we can proceed by video conference instead?
Yes. Your Honor.
If it becomes necessary to talk with your lawyer privately, we can accommodate that. Understood?
Yes.
If you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand?
I do.
Do you need any additional time to review the plea form with your lawyer?
No, I do not.
Do you need any additional time to review the criminal complaint in this case with your lawyer?
No, I do not.
According to the plea form, you are 29 years old. Is that correct?
Yes,
And you do have a high school diploma. Is that correct?
I do.
It sounds like you do understand English, correct?
Correct.
According to the plea form, you are not currently receiving treatment for mental illness or disorder. Is that correct?
Correct.
And you have had alcohol, medications, or other drugs in the last 24 hours?
Just like a Tylenol for my shoulder. That's about it.
Okay, and you're taking that according to the directions?
Yes.
Have you had any alcohol in the last 24 hours?
No, Your Honor.
The charge in count 1 is felony possession of methamphetamine. That is a class I felony with a maximum penalty of 3 years, 6 months imprisonment, or a $10,000 fine, or both. Do you understand that?
I do understand.
The elements of that offense are first, that you possessed a substance, second, that the substance was methamphetamine, and third, you knew or believed the substance was a controlled substance. Do you understand those are the elements of that offense?
I do.
Count 2 is misdemeanor possession of drug paraphernalia. That is a misdemeanor with a maximum penalty of 30 days imprisonment or a $500 fine or both. Do you understand that?
I do understand.
The elements of that offense are first, that you possessed an item. Second, you knew the item in question was drug paraphernalia. And third, you possessed the drug paraphernalia with primary intent to use it to ingest, inhale, or otherwise introduce it into the human body, a controlled substance. Do you understand those are the elements of possession of drug paraphernalia?
I do.
You understand I don't have to go along with any recommendation and I could sentence you up to the maximum penalty.
I do understand that as well.
If I place you on probation and your probation is revoked, I can sentence you up to the maximum penalty after probation revocation. Do you understand that?
I also understand that as well.
The criminal complaint outlines the facts that the state believes are true. Do you agree that there are enough facts in the criminal complaint to support your no contest plea to both of these charges?
I do.
Attorney Zawada, do you agree with that as well?
Yes, Your Honor.
And I have reviewed the criminal complaint and I will find there is a sufficient factual basis for the plea to each count. You have the following constitutional rights: the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty, your right to remain silent, your right to testify and present evidence, your right to use subpoenas to require witnesses to come to court, your right to confront and cross-examine witnesses who testify, and your right to make the state prove that you're guilty beyond a reasonable doubt. Do you understand you'd be giving up those rights by entering a no contest plea?
I understand.
Do you understand if I accept your no contest plea, I will find you guilty of the offenses?
I do.
Are you doing this of your own free will?
I am.
Has anybody put any pressure on you or forced you to make a plea?
No, Your Honor.
Count 1 is a felony, so you may not vote in an election until your civil rights are restored. Do you understand?
I am okay with that.
And you also may not possess a firearm because of the felony conviction. Do you understand? Do you understand?
I do.
Do you need any,
Yes, I do, sir.
do you have any questions about anything we've talked about so far?
I do not.
Attorney Zawada, are you satisfied your client is freely, voluntarily, intelligently, and knowingly making this plea?
Yes, Your Honor.
Are you satisfied he understands the elements, the facts, and the rights he's giving up?
Yes, Your Honor.
Then Mr. Robinson, as to count 1, felony possession of methamphetamine, what is your plea?
No contest.
And as to count 2, misdemeanor possession of drug paraphernalia, what is your plea?
No contest.
I will accept the no contest pleas. I'll find that they've been freely, voluntarily, intelligently, and knowingly made. I'll find he understands the elements, the facts, and the rights he's giving up, which we've reviewed here today. And I'll find him guilty of each of the 2 offenses, ordering a judgment of conviction entered into the record. And then ADA Linson, what is the, well, actually, this is a felony, so we could order a pre-sentence investigation. Attorney Zawada, did you want to order a PSI or proceed to sentencing today?
No, Your Honor, we're prepared to proceed to sentencing today. Thank you.
Okay, ADA Linson, were you prepared for sentencing today?
We are, Your Honor, and my understanding is that this will be a joint recommendation.
Okay, you can continue.
Your Honor, the state's requesting what is essentially time served. Mr. Robinson has been in custody for, he has 106 days credit at this point, which is essentially a little less than,
He's 3 minutes away.
which is essentially a little less than 5 months of jail with good time. Given the nature of the charges alleged, the state feels that that is a sufficient punishment. We would be requesting the court to sentence Mr. Robinson to time served. As far as his record, he has one criminal conviction. It's from 2010. It's a second-degree sexual assault of a child. He did receive prison imposed and stayed and was placed on probation for that matter. That activity, while notable, doesn't appear to have much of a relation to the offense that we're here for today. This would be the first drug conviction or drug-related conviction on his record. And based on that, we believe the amount of time that he's already served is a sufficient punishment.
Attorney Zawada?
Your Honor, this is a joint recommendation. We believe that 106 days that he has of credit as of today is an appropriate sentence for this case here. Your Honor, Mr. Robinson was caught with a 0.1 gram of meth, which is a small amount, and that's why we believe that time served recommendation is appropriate here. Additionally, Mr. Robertson has been crime-free from 2010 on, so this is a notable blip in his otherwise good character that he's had in the past 10 years here. Your Honor, Mr. Robinson also has so the support system here in the community. He's got his brother that lives here. He was living with his brother at the time. And so we believe that the time served recommendation here would be appropriate and ask that you adopt it. Thank you.
Mr. Robinson, now is your opportunity to address the court if you choose to do so.
I just want to say I do understand everything that's been going on today, and at that time I got in trouble. It was a really rough time in my life at that point, and I was doing good in the community even though I wasn't in contact with the courts. So I got everything situated and figured out for when I do get released. And thank you for your time and all that.
Thank you. When I issue a sentence, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, the character of the defendant, and deterrence of others, then apply the Gallian sentencing factors to those sentencing objectives. In this case, it sounds like there's one prior conviction on your record. It's from a long time ago, but it is a very significant charge that you were convicted of. However, you're not here for sentencing today on that case. You're here for sentencing on what does appear to be a pretty small amount of methamphetamine. It's probably visible dust in a bag, the amount of 0.1 grams. Methamphetamine is a very addictive substance that has a significant negative impact on its users and on neighborhoods in our community. And you've probably seen that in your own life, Mr. Robinson. The recommendation here today is just for straight jail time. And you've been sitting for 106 days, which is a significant penalty. So it's really going to be on you to go get treatment so that this doesn't happen again. Because if you come back with another possession of methamphetamine case, your lawyer can no longer say your one conviction was a long time ago. If you come back next year, they're going to say you were just convicted of possession of methamphetamine in 2021. So the rates of the criminal convictions do add up. So you need to get a handle on this right now in your own life so that you don't keep coming back. When I consider all of the Gallian factors in light of the sentencing objectives, I do think the joint recommendation for time served is appropriate. So the sentence will be 106 days jail with 106 days credit. You do have to pay the court costs, and on each count, that's going to be several $100s. $1,001 total. So even the court costs will be a significant penalty in and of itself. You'll have 6 months to pay that. That is a large amount. If you don't have it paid in 6 months, don't ignore it. Make sure you set up a payment plan with the clerk of court's office if it's not paid within 6 months. Anything additional from the state?
Not at this time, Your Honor.
Attorney Zawada, if you could review the post-conviction rights, anything additional from you?
Nothing further, thank you.
Well, I guess I do have to say it. Well, the 106 days jail will be on count 1, and then count 2 will just be court costs only.
Thank you.
And then that's all for today. Thank you. And now we're moving on to the 230 cases. If a lawyer has a case that you think will be quick, now is the time to say something. Attorney Herman, I see you raising your hand.
Yes, ours will be quick.
I see Mr. Castor. This is Brown County case number 19 CF 1782, State of Wisconsin versus James Robert Castor. The state is here by Assistant District Attorney Aaron Linson. Attorney John Herman is here. Mr. Castor is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Herman, what is our status here today?
Thank you, Your Honor. At this point, we're not resolved. I don't know that that's going to be possible, but I do want to make one more attempt at that. There are some records I want to collect that Mr. Castor referred me to. So if we could have one more clear status dates.
How about Monday, March 8th at 2 o'clock?
Thank you, that would work.
Mr. Castor, did you hear that date and time?
Yes, Your Honor, Monday, March 8th at 2 o'clock.
Yes. ADA Linson, anything additional from the state?
At this time.
Then bond continues, and that's all for today on that case. Attorney Stebbins, what about your case?
It'll be quick, Your Honor. Just scheduling.
Jonathan Morris.
I believe he's at.
Your Honor, could I be put in a breakout room with Mr. Celio Jaimes, who is appearing from the jail right now?
Yes, thank you for
Thank you.
saying that, so that we can do it while we're calling cases. Okay, breakout room is created. Okay, looks like they're there. Jonathan Morris.
I know he was having difficulty with Zoom, but I believe he called in. I think he might be at that 414 number.
Okay, and I did have to mute that one because there was background noise. Jonathan Morris, if you're able to unmute your device. Jonathan Morris. I had to mute your device because there was background noise. I can't unmute it though. Sometimes *6 is a mute button. *6.
Okay.
Are you Mr. Morris?
Hey, how are you?
This is Brown County case number 19 CF 1883, State of Wisconsin versus Jonathan Laurel Morris. The state is here by Assistant District Attorney Aaron Linson. Attorney Scott Stebbins is here. Mr. Morris is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Stebbins, what is our status here today?
Thank you, Judge. The court might recall towards the end of 2020, we were scheduled for a jury trial. I believe it was adjourned once and then scheduled again for trial. At our last hearing, I do not believe Mr. Morris appeared, but I did indicate that I had had recent contact with him. At that time, the state made an offer to me that amended the charges from felonies to misdemeanors, but I hadn't had a chance to discuss that with Mr. Morris. I still haven't been able to discuss that with him. I believe a copy of it was sent to him, but I don't know if he received it. So I'm not quite sure what the status is, but we're not prepared to do anything today.
Okay. Are you meeting with clients in person right now or doing it in some other way?
It depends. We do allow it if circumstances require.
Okay. So Mr. Morris, you just need to be responsive to your lawyer so that he can talk to you about this case. and you can make a knowing decision on how to proceed. So it sounds like your lawyer is going to reach out to you again to set up a time to talk about the status of the case with you. If he has to leave a voicemail, make sure you return his call promptly. And if you have to leave a voicemail with him, make sure you do that, because you're not his only client either. He has a lot of clients.
All right.
We can set this for the next hearing. Attorney Stebbins, do you want sufficient time for a plea and sentencing if that's a possibility?
Yes, please.
Friday, March 26th at 1:30.
That's fine.
Friday, March 26th at 1:30. I know a representative from the victim has made appearances on this case. If you'd like to be heard on the scheduling, now is the time you can address the court. I mean, this case is from 2019, so if you wanted this case scheduled for trial to make sure it has an ending point, we could do that as well. And you can tell the court that now.
I'm okay with that date.
Okay. Friday, March 26th at 1:30. It's scheduled for a plea and sentencing, so it does have a half-hour block. I mean, obviously, it doesn't have to be a plea and sentencing, but just letting everybody know that I'm carving out sufficient time for it that day. Anything additional from the state?
Your Honor, just briefly, there was a CGS violation. It was dated December 30th, but there were some missed check-ins. I would just ask the court to address it. The state's not requesting any action at this point.
Yeah, I changed.
Well,
I'm sorry.
Mr. Morris, let your lawyer talk first. Attorney Stebbins, any comments?
I'm just reviewing the report now. I had previously missed it.
Well, let me just address Mr. Morris. So I'm talking to you, Mr. Morris. You don't have to respond to me. We have this criminal justice services obligation that people that are pending on the cases have to comply with while they're on bond. And you've been on bond for a long period of time in this case. A lot of that is due to adjournments based on the public health emergency. And now recently it looks like you've failed to comply with the check-ins. I believe those check-ins are just by telephone, so it should be really easy for you to comply with this requirement, Mr. Morris. So starting right now, you need to be in compliance. And I'm actually going to tell you that you have to call Criminal Justice Services by the end of the day today to check in.
Okay.
That number is 391-4866.
391-4866.
Yes, 391-4866.
Thank you.
So this is kind of the one and only warning that you're getting. If I get another report from CJS that says you're not in compliance, I'm just going to issue the bench warrant, because now this is the warning that you're getting.
Not a problem.
And then the court date we picked, March 26th at 1:30. Attorney Stebbins, anything else to address for today's purposes?
No, Your Honor. Mr. Morris, I would just say obviously prioritize contacting CJS, and then once you do that, you can give us a call and we'll get something set up.
All righty.
Okay, then that's all for today. Everybody may hang up. Bond continues.
Thank you.
Your Honor, if we may, could we do Rouse next? I believe DA Lizzie is here for that, and he's got somewhere to go.
Yes. This is Brown County case numbers 20 CF 370, 20 CF 1009, State of Wisconsin versus Ashley Rose Rouse. The state is here by District Attorney David Lassay. Attorney Quinn Jolly is here. His client, Ms. Rouse, is appearing by video with him. If we could see her on the video. Okay, thank you. We're doing the hearing by video conference because of a global, national, and local public health emergency. requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Jolly, what is our status here today?
Your Honor, I was able to provide Mr. Lassay with some information yesterday to try to get to a resolution in this case. He did get back to me today. There is some more information I do want to provide him, and I do want to meet with him in person to talk about this matter. We'd ask that this be set for one more status conference. I believe we could, within 60 days, come close to a resolution, if not have a resolution at that time.
DA Lassay, any comment from the state?
I have no objection to that, Your Honor. Mr. Jolly did provide me with some information. I responded to him today. I'm happy to have a conversation with him about a resolution.
For the next date, how about Monday, March 8th at 2 o'clock?
Do you have anything later in the day, Your Honor?
2:30, 3 o'clock, 3:30, 4 o'clock.
We do with 4 p.m.?
Yes. Monday, March 8th at 4 o'clock. And can you confirm that your client heard the date and time?
Yes. Yes, she has.
Thank you. Anything additional from the state?
No, Your Honor. Thank you.
Then bond continues, and that's all for today. Thank you.
Thank you, Your Honor.
Thank you.
Vincent Lemieux. Vincent Lemieux, I see your name there. If you could turn on the camera. Okay, can you hear us, Mr. Lemieux?
Yes.
This is Brown County case number 20 CF 833, State of Wisconsin versus Vincent Arthur Lemieux. The state is here by Assistant District Attorney Aaron Linson. Attorney Brianna Zawada is here. Mr. Lemieux is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Zawada, what is our status here today?
Yes, Your Honor. I would be asking for another date in this matter. I did receive discovery earlier today. This was previously Attorney Abhi Samra's case, and I now have discovery in hand. So I'm asking that we set this for one more date so I can review that discovery with my client.
About Tuesday, March 9th at 1:30.
Did you say 1:30, Your Honor?
Yes.
I'm in branch 7 at that time. The rest of the day is free whenever else you have availability.
3:30.
Perfect. Thank you.
Tuesday, March 9th at 3:30. Mr. Lemieux, did you hear that date and time?
Yes.
ADA Linson, anything else from the state?
Not this time.
Bond continues, and that's all for today. Thank you.
Thank you.
Thank you.
And then I'm going to close the breakout room. We have a case that's in the breakout room right now, and it's a case that with the individual at the jail, so I'm sure they want their device freed up. And then we also have the interpreter here for it. And when I close the room, it gives a 60-second countdown, which is down to 30 seconds now. Okay, looks like we have Attorney Fagundis. Did you need any additional time, Attorney Fagundis? I know we have a Spanish interpreter here.
I do need some additional time, but not today. We can proceed and call the case once he's back.
Yeah, we got to wait for him to come back. The countdown is down to 5 seconds. Okay, he's back.
And if you just allow me to introduce myself, that'd be great.
Okay, if you want to right now, you can.
Señor Jaime, soy la intérprete judicial. ¿Me oye?
Sí.
Ok, vamos a empezar.
This is Brown County case number 19 CF 1885, State of Wisconsin versus Celio Jaimez Gomez, I apologize.
Este es el caso del condado Brown número 19 CF 1885, el estado de Wisconsin contra Celio Jaimez Gómez.
The state is here by Assistant District Attorney Aaron Linson.
El estado está aquí, el subfiscal Aaron Linson.
Attorney Luca Fagundes is here. His client, Mr. Jaimez Gomez, is appearing by video from Brown County Jail.
El licenciado Luca Fagundes está aquí. Su cliente, el señor Jaimez Gómez, está compareciendo por video desde la cárcel del condado Brown.
We are doing the hearing by video conference because of a global, national, and local public health emergency.
Estamos haciendo la audiencia por videoconferencia por una emergencia global, nacional y local de la salud pública.
We are live streaming on YouTube for public access. There is no one in the courtroom gallery.
Estamos transmitiéndola en vivo por YouTube para que tenga acceso el público. No hay nadie en los asientos públicos de la sala de justicia.
Attorney Fagundes, what is our status here today?
Licenciado Fagundes, ¿cuál es el estado de esto hoy?
Your Honor, yesterday I filed a plea questionnaire with the court that I wanted to proceed on today. However, go ahead, Sarah.
Su señoría, ayer presenté en el tribunal un cuestionario declaratorio con el cual quería proceder hoy, pero sin embargo,
I didn't put the interpreter appearance on the record. Certified Spanish interpreter Sarah Fascheski is here. She has been previously sworn and will continue to be sworn.
no hice constar en el acta que está aquí una intérprete. La intérprete certificada Sarah Fascheski está presente y previamente fue juramentada y así continuará.
So, during the breakout room, I was reviewing this plea with my client. He indicates he did not sign this document.
En la sala privada revisaba el cuestionario, revisaba la declaración con mi cliente. Él me avisó, no firmó este formulario.
We asked the jail we faxed the document to the jail to have him sign and return to us because our mailings weren't getting to him. However, they faxed us something back and apparently this is not his signature.
Le habíamos pedido a la cárcel, es que mandamos esto por fax para que él lo firmara y nos lo devolviera porque, no sé, por alguna razón no le llegaban las cosas que le enviábamos por correo, pero nos enviaron algo devuelto por fax y aparentemente esta no es firma de él.
So at this time, Your Honor, I'm asking for this to be rescheduled as soon as possible for another plea, but I do need some time to get another plea form to him or get it signed so I can get it filed with the court.
Así que ahora mismo, señoría, estamos pidiendo que reprograme esto para una fecha lo más antes posible, para otra vez hacer una declaración, pero sí necesitaré tiempo para hacer lo del cuestionario declaratorio para que le llegue, para que lo pueda firmar y para que lo pueda presentar yo.
How about Friday, February 5th at 3:30?
¿Qué tal el viernes 5 de febrero a las 3:30?
That's perfect, Your Honor.
Está perfecto, señoría.
If there's anybody on the call who's here on behalf of the victim and you'd like to be heard on the scheduling, please say something now, or you can continue to remain silent.
Si hay alguien presente en esa llamada en nombre de la víctima y quisiera que se le escuche a usted sobre esta programación de cita, por favor diga algo ahora o puede permanecer en silencio.
Your Honor, my client's raising his hand for something. I'm not sure what.
Su señoría, mi cliente está alzando la mano para algo, no estoy seguro qué cosa.
We're scheduling your case for next week, Friday, Mr. Jaime Gomez.
Estamos programando otra audiencia para su caso para el viernes de la próxima semana, señor Jaime Gómez.
Friday, February 5th at 3:30.
El viernes 5 de febrero a las 3:30.
I believe your lawyer is intending to send you the document again to make sure you receive it.
Creo que su abogado tiene pensado volver a enviarle el documento para que puedan hacerlo.
Attorney Fagundes, anything additional for today's purposes?
Señor Fagundes, ¿algo más para propósitos de hoy?
No, Your Honor, thank you.
No, su señoría, gracias.
ADA Linson, anything else?
No, Your Honor.
¿Su fiscal Linson, algo más? No, su señoría.
Your Honor, if possible, could I just have 30 seconds in a breakout room once we adjourn, if that's okay, unless they're being taken up?
Su señoría, si es posible, puede darme una sala privada por unos 30 segundos una vez que aplacemos el caso. Si está bien, si no están todos ocupados.
Bond continues. I'll create the breakout room, but I'll have to close it after a couple minutes because they do want their devices freed up.
Continúa la caución. Sí puedo generar otro cuarto privado, pero lo tendré que cerrar dentro de unos minutos porque ahí ellos quieren que los aparatos estén desocupados.
Thank you.
Gracias.
So then the breakout room is created if you want to accept the prompt. If you can tell Celio to accept the prompt to go in the breakout room.
Oh, here they come.
And I'll close it after a couple minutes.
Yeah.
So you do not need the interpreter for any other case, I think?
I don't believe so, no.
All right, thank you.
Okay, thank you, Sarah. We're on to the 3 o'clock cases now. I believe we have 5 cases at 3 o'clock. Attorney Detert, what are we doing on your case?
Your Honor, I'm just going to ask for another status conference. I've got new discovery I just received.
Okay, Paula Ninham. Paula Ninham. I did have to mute a few devices because there was background noise. If you're Paula Ninham, and you can please unmute your device.
Hello?
Are you Paula Ninham?
Yes, I am. I'm Paula.
Okay, we're calling your case right now. This is Brown County case number 19 CF 1896, State of Wisconsin versus Paula Margaret Ninham. The state is here by Assistant District Attorney Aaron Linson. Attorney Eugene Detert is appearing by video. Ms. Ninham is appearing by audio. We're doing the hearing by video and audio conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Detert, what is our status here today?
Your Honor, I'm still reviewing the original discovery I received in this case, and I just received another discovery disc, I believe, on Saturday. I'm asking for one more status. I don't believe I have an offer yet or attorney about resolving the case yet because I haven't completed my review of the discovery. Because I have a 2-week trial in Marathon County starting February 22nd, and I have a vacation after that, I would ask that we schedule it possibly for the week of March 29th or April 5th, if that's available on the court's calendar.
I have, my criminal week is March 22nd. Are you available on March 22nd?
Only if I appear from Phoenix. And I'd have Wi-Fi, but there is a time difference too, a 2-hour time difference.
Otherwise, the next criminal week is April 5th. April 5th at 1:30.
Yeah, that would be fine.
Monday, April 5th at 1:30. Ms. Ninham, did you hear that date and time?
Yes, I did.
ADA Linson, any additional comment from you?
I would just note that there is an offer in the file. I'll have it resend to Attorney Detroit.
Thank you.
Then bond continues, and that's all for today on Ms. Ninham's case. Thank you.
Thank you, Judge.
Thank you.
Attorney Pappas, what is your case looking like today?
Yes, thank you, Your Honor. Well, it's pretrial and the, standard pretrial and that there's no resolution and we have a trial scheduled. And so we're just asking that the trial commence as scheduled.
We can call it then. This is Brown County case number, well, actually, let me make sure she's here. Kayla Klarner. Kayla Klarner. Kayla Klarner.
I was, if she's not on, I'm surprised. I was having trouble reaching her and that's unusual for her.
Okay. There are 2 unknown devices on the Zoom feed. I did have to mute them because there was background noise, but I can't unmute them. So if we have Kayla Klarner, if you could unmute your device.
Her number would be a 256 or something. So I don't think she's on.
Okay, why don't you try giving her a call right now then?
Sure. Yeah, I did.
We'll call a different case.
Sure. Thank you. I'll do that.
Rick Andrus.
That's my case, Your Honor.
Okay. Rick Andrus, if you can unmute your device. Rick Andrus. Rick.
Hello?
Okay, you're Mr. Andrus?
Yes, I am.
This is Brown County case number 20CM380, 20CM1375. State of Wisconsin versus Rick Michael Andrus. The state is here by Assistant District Attorney Aaron Linson. Attorney Matthew Graves is appearing. Mr. Andrus is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Graves, what is our status here today?
Your Honor, we do have the 2 cases for Mr. Andrus. Although discovery in the second case, I only received late last week. I have not had a chance to go over it with my client yet. And based on a few things that he said, I believe there's going to be a significant amount of investigation that needs to go into the second case. So we're going to ask for another status date.
How about Monday, March 8th at 30?
That works for me.
What time is that?
2:30.
Yeah, that should work.
Monday, March 8th at 2:30. Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you.
Thank you. Bye.
Attorney Shears, what are we doing on your case?
I'm going to need a date, Your Honor.
Kiara Marshall? This is Brown County case number 20 CM 670, State of Wisconsin versus Kiara Marshall. The state is here by Assistant District Attorney Aaron Linson. Attorney Travis Shears is appearing by video. Ms. Marshall is appearing by video as well. We're doing the hearing by video conference because of a global, national, and local public health emergency. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Shears, what is our status here today?
Your Honor, when we were here last, we had requested an adjournment from my client to obtain an anger management assessment. She has done that. Proof of that has been submitted to the DA's office. However, I've been unable to connect with Attorney Schuckert to finalize our negotiations. As such, I'd ask that the matter be rescheduled for a plea and sentencing hearing. I do note that I would not be available on March 8th or 9th.
Would you be available on March 12th? That day?
Anytime.
How about 10:30?
That's fine.
Friday, March 12th at 10:30. Ms. Marshall, if you can just confirm that you heard that date and time.
That works.
ADA Linson, anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you, Your Honor.
Ayla Klarner.
Yes, thank you, Your Honor. So I tried to call her again, just like I did before, and email her as well and such, and I'm not getting responses from her. Again, very unusual for her.
Well, we can either call it or we can call the individual that's in custody. It's up to you if you want to wait longer or not.
Yeah, I'm at my desk, Your Honor. It doesn't matter. I'm happy to wait.
Okay. There's actually, well, Attorney Zawada, let's call your case next. This is Brown County case numbers 20 CF 410, 20 CF 1182. They're both State of Wisconsin versus Devin Thomas Sternhagen. The is here by Assistant Attorney Aaron Linson. Brianna Zawada is present. Mr. Sternhagen is appearing by video from the Brown County Jail. And we do hear some background noise, so I am going to mute it until Mr. Sternhagen needs to talk. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Zawada, what is our status here today?
Your Honor, we are planning on entering pleas today. However, I believe the parties do agree that we are not planning on proceeding to sentencing today. Both parties are looking into various issues and need a little time for that before sentencing. And I believe we will be asking, based off of the pleas that he be given signature bonds, the offer in this case is for no more jail than he sat already. And I believe the state will not take a position on that signature bond.
Okay. Have you talked to your client about the video conference appearance?
Yes, he does want to proceed by Zoom today.
Okay. It looks like the plea is to entry into a locked building, lewd and lascivious behavior, and felony bail jumping. And the plea will be no contest. Is that your understanding, Attorney Zawada?
Yes, Your Honor.
ADA Linson, is that your understanding?
Correct, on the two different files, but yes.
And Mr. Sternhagen, is that your intent to plead no contest to those three charges? And now we do need to unmute it. Thank you.
Yes, Your Honor.
Okay. You do have a right to be present in person in the courtroom for a plea hearing. Are you willing to waive your right to be present so that we can continue with this video conference?
Yes.
Are you able to see me and hear me clearly?
Yes.
and I am able to see you and hear you clearly as well. The state in compliance with victim notification.
We are, Your Honor.
If you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that, Mr. Sternhagen?
Yes. Yes, I do.
Around that day, I was kind of feeling sad about catching a new case and all that stuff. Everybody in the room was fresh, kind of locked up, and I was kind of sad. I'm like, man, I'm ready to end it all type shit.
Your Honor, I do believe the state would need to file the amended information still.
Fucking around.
Why don't you do that right now? And we'll go off the record. We can hear somebody in the background. What's going on behind you, Mr. Sternhagen?
There's somebody else in a professional visit.
Yeah,
It should be filed.
is it in there?
If anyone needs me to email them a copy, please let me know.
Me and one of the guys and stuff, he was like, he had shown me
Yeah, there's no way that the court reporter is going to be able to hear Mr. Sternhagen. I mean, we can hear that conversation as clearly as we can hear him. Is there anything that can be done about it? I know you're dealing with what.
Yeah, I'm in a pod where these inmates are in SEG. They're belted. So he's belted in professional visiting. I have him belted to a stool here.
So you can't unbelt him from where he is.
I could try and move him down, but yeah, I need another officer to do it.
Okay.
Okay.
Are they able to talk quieter?
I asked, and
We can hear them just as easily as we can hear Mr. Sternhagen.
Okay.
Well, we're still processing a document here. Let me think about it, about what we can do.
Yeah, I'll try and move him down.
Okay. He's in there? No, not yet.
Okay. Your Honor, he's back.
Okay, thank you. That is better. Yes, thank you. We're waiting for the information to come through. Okay. Is it just in the 20 CF 410?
That was my understanding.
Okay.
I see it in my e-filing documents now
Okay, I see it too.
as a document number 40.
Okay. We'll go back on the record. All the parties are here. Mr. Sternhagen, can you confirm that you can hear me and see me okay?
Yes.
Okay.
Yeah.
According to the plea form, you are 19 years old. Is that correct? Yeah, I see that, yeah.
Just reading.
According to the
Can you
plea
repeat that, Your Honor?
I will, yes. According to the plea form,
You just froze.
You're 19 years old. Is that correct?
Yes.
And
Yes.
you do have a high school diploma or an equivalency degree?
Keep on doing it, which is not-
Yeah, it does seem to be skipping every once in a while.
Yeah, and Your Honor, I do want to correct that as well. He was currently working on his HSED, but that's my mistake that I clicked that he does have it. He does not yet have his HSED.
Okay. Well, I don't know if our connection's going to be well enough here. I guess what we could do is we could do the signature bond modification without taking the plea even. Let's see what the benefit of taking the plea would be if he's out of custody anyway. I would require him to apply with criminal justice services. Then he wouldn't be at the jail to make the next appearance.
That's right, Your Honor. I would also like to note for the record that he's also on juvenile probation as well. So he would be on a hold for at least a few more days as his PO sets up a place for him to go. And then at that time, he would still be monitored in the community in the meantime while awaiting police sentencing.
Okay. ADA Linson, what do you think?
I don't like the idea, but I'm not sure we have a better option at the moment unless we're able to delay this for a period of time. I don't know
Okay.
what the court's calendar is.
The video feed does look a lot better. Can you hear us, Mr. Sternhagen?
Yeah, it's a little skippy, but it's better than before.
Okay, well, it is. I think it is better than before too, so we'll try to continue. You don't have your equivalency degree, but you're working on it, your high school equivalency?
Yeah, I'm working on it. I just I started it at Mendota, but I never got to finish it because I left.
Okay. And you do understand English, correct?
Yeah. Yes.
You are not currently receiving treatment for mental illness or disorder, is that correct?
What do you mean by treatment?
The statement stands for itself. Are you receiving any treatment for mental illness or disorder right now?
Not while I'm in jail, but when I'm on the outs, I usually have a therapist.
Okay. Are you taking any medications right now?
No.
Have you had any alcohol or other drugs in the last 24 hours?
No.
Have you been able to understand all the questions that I've asked you so far?
So far, yeah.
In 20 CF 410, the charge in count 1 is misdemeanor entry into a locked building. That's a maximum penalty of 9 months jail or a $10,000 fine or both. Do you understand that's the maximum penalty?
Yes.
The elements of that offense are first, that you entered the dwelling of another. Second, you entered the dwelling when it was locked and enclosed. Third, you entered the dwelling without consent. Do you understand those are the elements of entry into a locked building?
Yes.
As to 20 CF 1182, count 1 is misdemeanor lewd and lascivious behavior. The maximum penalty is 9 months jail or a $1,000 fine or both. Do you understand that?
Yes.
The elements of that offense are first, that you exposed your genitals or pubic area. Second, you exposed your genitals or pubic area publicly. That is, not in a hidden manner, but open to view. Third, you exposed your genitals and pubic area indecently. Do you understand those are the elements of lewd and lascivious behavior, exposing genitals or pubic area?
Yes.
Count 3 is felony bail jumping. That is a class H felony with a maximum penalty of 6 years imprisonment or a $10,000 fine or both. Do you understand that?
Yes.
The elements of bail jumping are first, that you were charged with a felony. Second, you were released from custody on bond. And third, you intentionally failed to comply with the terms of bond. Do you understand those are the elements of felony bail jumping?
Yes.
In each case, there's a criminal complaint that outlines the facts that the state believes are true. Do you agree that there are enough facts in each criminal complaint to support your no contest plea to these charges?
I don't really know what that means.
Okay.
Why?
There's a criminal complaint that the state files, and that begins the whole case. It lists your charges, and then it also has a probable cause section that lists the facts. A lot of times the facts are based on police reports and statements from witnesses. Do you agree that there are enough facts in the criminal complaint in each case to support your plea to each of these 3 charges?
Yes.
Attorney Zawada, do you agree with that as well?
Yes, Your Honor, I do.
And I have reviewed the criminal complaint in each case, and I will find there is a sufficient factual basis for the plea. You have the following constitutional rights: the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty, your right to remain silent, your right to testify and present evidence, your right to use subpoenas to require witnesses to come to court, your right to confront and cross-examine witnesses, and your right to make the state prove that you're guilty beyond a reasonable doubt. Do you understand you'd be giving up those rights by entering into a contest plea?
Yes.
Are you doing this of your own free will?
Yes.
Has anybody put any pressure on you or forced you to make a plea?
No.
Do you understand if I accept your no contest plea, I will find you guilty of the offenses?
Yes.
Do you understand that I don't have to go along with any plea agreement or any recommendation, and I could sentence you up to the maximum penalty? Do you understand?
Yes.
If I placed you on probation and your probation was later revoked and I had to sentence you again after revocation, do you understand I could sentence you up to the maximum penalty at that time?
Yes.
There are offenses being dismissed but read in. When they're dismissed, I cannot sentence you on that count, but when they're read in, I can consider the conduct as a whole. Do you understand?
Yes.
Do you understand I could order restitution to be paid to a victim, including on read-in offenses? Do you understand?
Yes.
There is a felony count you're pleading no contest to, so you may not vote in an election until your civil rights are restored. Do you understand?
Yes.
And you may not possess a firearm because of the felony conviction. Do you understand?
Yes.
Do you have any questions about anything we talked about?
No.
Attorney Zawada, are you satisfied your client is freely, voluntarily, intelligently, and knowingly making this plea?
Yes, Your Honor.
Are you satisfied he understands the elements, the facts, and the rights he's giving up?
Yes, Your Honor.
Mr. Sturhagen, in 20 CF 410, as to count 1, misdemeanor entry into a locked building, what is your plea?
I don't know, Brianna, what,
The plea form is marked no contest. Attorney Zawada, was that your client's intent?
It was, and that is what we discussed, that he'd be entering a plea to no contest.
Okay, I will repeat the question. In 20 CF 410, as to count 1, misdemeanor entry into a locked building, what is your plea?
I don't know what to say. Do I say, I'm so confused. I'm sorry.
What do you, the options are not guilty, no contest, or guilty. The plea form is marked no contest, is what you're intending to plead. Do you need any additional with your lawyer?
I would like to talk with my lawyer to kind of understand this a little bit more.
Sure.
Okay. Attorney Zawada?
Yeah, sure. If we could do a breakout session. Thank you. Thank you.
And the court staff's going to take a 5-minute break too.
I think it froze. I think when we take a break, he takes a break too.
Yeah, we're just waiting for the court staff to come back now. Attorney Zawada, you were able to go into the breakout room, right?
Yes, we were. It was a brief discussion.
Okay. For individuals that just signed in, we're completing the last from the 3 o'clock calendar and then calling 3:30 cases. Oh, it's actually additional case with Attorney Pappas. Were you able to get a hold of your client, Attorney Pappas?
No, actually, I wasn't.
Okay.
And I don't think she's ever missed court before, Your Honor. Oh, wait, I think oh, never mind. I thought I saw her. Oh, yeah, Kayla. It looks like she is on now.
I think there's a Kayla at 3:30 also, though.
Oh, okay, different Kayla. Okay.
That's my Kayla.
Yeah, I couldn't get a hold of my client then, Your Honor, so the court can call it whenever.
Okay. Well, let's finish this hearing real quick.
Sure.
We're back on the record in Mr. Sternhagen's cases. The appearances are all the same. Attorney Zawada, have you had time to talk to your client privately in a breakout room?
I have, Your Honor.
Is he ready to continue with the plea today?
He's ready to proceed. Thank you.
Okay. So, Mr. Sternhagen, did you have enough time to talk to your lawyer in the breakout room?
Yes.
Okay. And do you want to still enter a no contest plea here today?
Yes.
Then in 20 CF 410, to the charge in count 1, misdemeanor entry into a locked building, what is your plea?
No contest.
And then in 20 CF 1182, as to count 1, misdemeanor lewd and lascivious behavior, exposing genitals or pubic area, what is your plea?
No contest.
And as to count 3, felony bail jumping, what is your plea?
No contest.
I will accept the no contest pleas. I'll find they've been freely, voluntarily, intelligently, and knowingly made, that he understands the elements, the facts, and the rights that he is giving up. I will find him guilty of each of the 3 offenses and order judgment of conviction entered into the record. And then we're scheduling for sentencing. We're not asking for a PSI though, Attorney Zawada?
That's right, Your Honor. Ultimately, this is a misdemeanor conduct with the exception of the felony bail jump is how it's a felony. So we believe it's appropriate to schedule sentencing without a PSI.
And the state's not asking for a PSI, correct?
Correct, Your Honor. We did submit a letter to the court. Basically, we're looking to obtain some juvenile records. I guess the state would be looking for direction from you as to how you wanted us to proceed with that request. We would be asking for those prior to the sentencing.
I will sign those requests unless you have an objection that you want to be heard on, Attorney Zawada.
No, Your Honor.
Then I will sign the request for the release of information from those 2 cases. How about Friday, March 5th at 4 o'clock?
At 4 o'clock, did you say?
Yes.
That works. Thank you.
And then is the state agreeing to bond modification?
We wouldn't object to a modification to a signature bond with the original conditions pursuant to the plea.
So Mr. Sternhagen, I am going to grant the request to modify the bond to a $10,000 signature bond. So you should be released from custody today. You are going to be required to check in with Criminal Justice Services by noon tomorrow.
Okay.
And then
Your Honor, I also want to note for the record that he also has that juvenile probation agent who likely will have a hold on him for at least the next few days. So if you could have them check in by noon the day after he's released.
yes, it'll be check in by noon the day after you are released.
Okay.
And then you have to follow through with making with the requirements of criminal justice services.
Okay.
The court date is Friday, March 5th at 4 o'clock. Anything additional from the state?
Not at this time, Your Honor.
Count 2 in 20 CF 1182 and count 2 in 20 CF 410 will be dismissed but read in. Is that correct, Attorney Linson?
It is, Your Honor.
Then those will be dismissed but read in. And then the bond is amended to the $10,000 signature bond in each file. And then that's all for today. Thank you.
Thank you.
Well, it's $10,000 now. Attorney Pappas, this is Brown County case number 20 CF 466, State of Wisconsin versus Kayla Lee Klarner. The state is here by Assistant District Attorney Aaron Linson. Attorney George Pappas is present. Ms. Klarner does not appear. She's not on the video conference. We're doing the video conference because of a global, national, and local public health emergency. We're live streaming on YouTube. There's no one in the courtroom, and the courthouse is open to the public, so she would be able to walk into the courtroom unrestricted. Attorney Pappas, have you had recent contact?
No, Your Honor, I think if memory serves me correctly, we were last in court and this date was set when my client was with me. So I think she had actual notice. But having said that, thereafter, I had little communication with her. I think we spoke after that court date, but nevertheless, today I could not reach her by email, phone. I tried multiple times. That's quite unusual for her. I don't think she's ever even been late to an appointment for me, let alone late for court. Oh, and as I sit here, I see my phone is ringing and it's Kayla.
Okay. Do you want to put it on speakerphone?
If you don't mind, Your Honor. Yes. Thank
Yeah.
you. Kayla? Kayla?
Yeah.
We are in the middle of court, so if you could speak loudly, and we're going to address a few matters with Judge. Okay?
Okay. And I could hear her voice in the background. Attorney Pappas, you're satisfied that's your client?
It is my client. Yes, I understand. I recognize her voice.
Okay, so Ms. Klarner is now appearing by phone. She doesn't need to talk, so we only have one.
Don't worry, Kayla. Just hang tight.
This is scheduled for trial February 24th. Is there anything to address today, Attorney Pappas, from your perspective?
No, not really. The only issue I want to flag, well, I guess there's one thing, but we don't have to address it today. I just want the court to note that the assigned prosecutor and I had discussed redactions of the recording of the trial. And I think that we're going to need some of the court's time, whether before or at the trial, to address that.
Okay.
But I think maybe too, though, Mr. Saunders and I'll have an agreement and a redaction all put together before we even come in.
Why don't we schedule the case again for Monday, February 15th at 2:30?
One issue with that, I'm currently set for jury selection for branch 3 that afternoon.
How about Friday, February 12th at 11 o'clock?
Yes, that works.
Friday, February 12th at 11 o'clock.
Did you hear that, Kayla? Kayla?
Yep, I heard it.
Okay, and I heard her say that she heard the date.
Yes.
the February 24th date, there are two cases that are pretty significant felony charges with individuals in custody. That would definitely be a higher priority than this case, just to let everybody knows. But that doesn't mean that those are definitely going, but they are on the schedule.
Okay.
Anything additional from the state?
Not this time, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you. Kayla? Kayla?
Cordell Johnson.
Yes, Your Honor. He's right next to me. I'll move
Okay.
the screen.
Are we doing anything other than scheduling on your case?
No, Your Honor. And I can advise why if you'd like. Otherwise, we can keep going.
Well, we'll call the case first. This is Brown County case number 20 CF 239 and 20 CF 938. State of Wisconsin versus Cordell Martez Johnson. The state is here by Assistant District Attorney Aaron Linson. Attorney Jevin Giacone is here. With him is Mr. Johnson appearing on video. I believe they're at his office. The hearing's being done by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Giacone, what is our status here today?
Yes, Your Honor. Attorney Potsky and I are getting closer to a resolution, so we would ask to do it in 1 month. It was slowed down. Unfortunately, tragically, the defendant's father passed away recently, so we haven't had a lot of time to chat. I apologize.
Okay. But are you pretty confident that it could be a plea and sentencing at the next hearing?
At least a plea for sure.
How about Friday, March 26th at 10:30?
Yeah, that would work.
Friday, March 26th at 10:30. Mr. Johnson, did you hear that date and time? If he responded, we didn't hear.
Oh, yes, he did. Sorry about that.
Yes, I did. Okay, thank you. Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you, Your Honor. I can advise Mr. Minnie is on one of the phone lines ending in 3937 if you'd like.
Okay, you have another.
That was a 3:30. There's a 4 o'clock, but I don't want to cut in front of anyone.
Oh, I see the 3 o'clock in there. Okay. Well, let's do your cases, Attorney Giacone, if they're just, is this one just scheduling too?
Correct. If you
Okay.
want, we could do the same date. Thanks.
Troy Many?
He'll
Troy
be on
Many?
the- Yep, he's on the 3937 line, if that helps.
Troy Many?
Yes. Okay, good.
This is Brown County case number 20 CF 704, State of Wisconsin versus Troy Jason Many. The state is here by Assistant District Attorney Aaron Linson. Attorney Jevin Giacone is here. Mr. Many is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Giacone, what is our status here today?
Similar to the last case, we're making progress. The defendant did give me some discovery yesterday, so I'll go over that with Attorney Lucher. If you want that same 26 date, either like a half hour before or half hour after, depending on the court calendar.
How about Friday, March 26th at 11 o'clock?
Sounds good.
Okay, I think that was Mr. Many that said that. So Attorney Giacone, are you, does that work on your calendar?
Oh, yeah, I'm sorry. Didn't mean to overcut.
ADA Linson, anything else from the state?
No, Your Honor.
And bond continues, and that's all for today on Mr. Many's case.
Thank you, Your Honor.
Jacqueline Abernathy.
Yes.
Okay, we can see you. This is Brown County case numbers 20 CM 308, 20 CM 837, State of Wisconsin versus Jacqueline K. Roa Abernathy. The state is here by Assistant District Attorney Aaron Linson. Ms. Abernathy is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency. We're live streaming on YouTube. There's no one in the courtroom gallery. Ms. Abernathy is not represented by a lawyer. Did you want to be represented by a lawyer?
No. No.
Okay. You understand that these are criminal charges that are pending against you. Do you understand?
Yes.
The charges are criminal damage to property as a domestic abuse, disorderly conduct as a domestic abuse offense, and misdemeanor bail jumping as well. You understand that?
Yes. Yes.
Is there a little bit more quiet location you can go to?
There, at the moment, there's not. It kind of ran through to an appointment that I had.
Okay.
So I put my AirPods in though.
Okay. There's no corner you can go to where there's less people?
There's really not.
Okay. Okay. I believe that Ms. Abernathy has waived her right to attorney previously, and she intended to talk to the DAs on the case. ADA Linson, do you have a record of her talking to the ADA?
I do, Your Honor. It appears that Ms. Abernathy indicated to our office that she wasn't interested in the offer.
Okay.
So at this point, I think we just want to calendar this for trial.
Okay, so we're gonna put it on the trial calendar, Ms. Abernathy. Do you understand that?
Yes.
And you don't want to be represented by an attorney at a trial?
No, thank you.
Did you understand that I'm not going to treat you any differently whether you have an attorney or not?
Yes.
And you have to follow all the rules of the court, whether you have an attorney or not. Do you understand that?
Yes.
For instance, you have to follow all the rules of evidence. You understand that?
Yes.
And a lawyer would have actual knowledge of how to utilize the rules of evidence, which I assume you don't have a full understanding of, but you have to follow the rules of evidence during a trial. Understood?
Okay.
We'll schedule it for Wednesday, April 7th. The DA's office has the burden of proof, so they'll decide which case tries first. Jury selection will be Tuesday, April 6th at 1:30. And then we'll have a final conference Tuesday, March 23rd at 1:30.
Is that March 21st at 2:30?
March 23rd at 1:30.
Oh, thank you.
Did you get all those dates, Ms. Abernathy?
And I would get.
Okay.
But would they also? Would they come in the mail?
Yes, the documents will be mailed to you. Yes.
Okay, then yeah, that's fine.
Anything else from the state?
Your Honor, I guess I don't know if Ms. Abernathy intended to have a jury trial or a bench trial. I don't know if that question was ever posed to her.
Okay. So Ms. Abernathy, you have a right to a jury trial where 12 jurors would decide whether you're guilty or not guilty, and all 12 would have to agree either way. or you can have a trial to the court where I would be making the decisions. Did you have a request for which one you'd like to do? Okay, I don't think we have.
I'd rather go with I'd rather skip the jury and just go with you.
Okay, so it won't be a jury trial then. I think you said you wanted to skip the jury and go with me.
Yes.
Okay. The next court appearance is March 23rd at 1:30. And I think I want you to be in the courtroom. We can go over what the courtroom is like leading up to a jury trial, and you can at least be present in here before the trial day. So be present in my courtroom March 23rd at 1:30. Okay?
Okay. All right.
And then that's all for today. Thank you.
Thank you.
Yes, you can hang up now.
Hello?
We have many cases on the calendar. If you could please mute your device. If you could please mute your device until the case is called. Okay. Regina Moffett.
I'm here.
A lot of noise in the background.
I can't hear anything, Your Honor.
Yeah, it's not Ms. Moffitt's feed. I have everything else muted, so I don't know. If you could mute your device, sometimes stars will act as a mute button. Please mute your devices. Okay, whatever happened there seems to have solved it.
Hello?
What is your name?
Yeah, that's Flowers.
Okay, you got to mute your device.
Oh, I'm sorry. What do I hit? Star 6?
Yeah. This is, okay, we'll call Ms. Moffitt's case now. This is case number. Well, back. Yours.
It's Ms. Moffitt's.
Yeah, do you have a fan going on in the background or anything? It is coming from. Okay, well just leave it muted. We should, if we need to hear anything from you, then you can unmute it. This is Brown County case number 20 CF 519, State of Wisconsin versus Regina Ray Moffett. The state is here by Assistant District Attorney Aaron Linson. Attorney Thomas Erickson is here. Ms. Moffett is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Attorney Erickson, what is our status here today?
Your Honor, I received another disc of discovery a few days ago from the state. I haven't had a chance to review that. This case is related to a very large drug case in Green Bay as well as in federal court. So I'd ask for another status date at the next cycle.
How about Tuesday, March 9th at 9 o'clock?
Yeah, that's fine.
Tuesday, March 9th at 9 o'clock.
Thanks a lot.
And Ms. Moffett, if you can unmute it just to acknowledge that you received the date and time.
Yes.
Okay, thanks.
ADA Linson, anything additional? ADA Linson, anything additional? Attorney Aaron,
Nothing further from the
anything else?
state.
No, thank you.
Then that's all for today. Thank you.
Thank you.
Kayla Steiner. This is Brown County case numbers 20 CM 376, 20 CM 853, State of Wisconsin versus Kayla Lynn Steiner. The state is here by Assistant District Attorney Aaron Linson. Attorney David Matthias is here. Ms. Steiner is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Matthias, what is our status here today?
Your Honor, about a week and a half ago, I sent a letter to Ms. Schukert. I have not received a response. I'm hoping that letter can start a dialogue between myself and the state. So rather than schedule for a trial, I would propose another status, possible plea hearing.
ADA Linson, are you able to confirm whether it was received or not?
It was received. There's a note that we just haven't had a chance to review it yet. So we would agree with that request.
How about for scheduling Monday, March 8th at 1:30?
That works for me, Your Honor.
Monday, March 8th at 1:30. Can you acknowledge you heard the date and time, Ms. Steiner?
Yes.
Thank you. Anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
Thank you, Your Honor.
Deontay Ward. Deontay Ward. We have Attorney Holly, I see. We have a couple people that called in on the telephone. Or if you're Deontay Ward, if you could please unmute your device. I think one of the phone numbers was Mr. Flowers, so we're not to his case yet. Deontay Ward. Sometimes *6 will be a mute button. Attorney Holly.
Can you hear me?
Okay,
here.
I think we got him. You're Deontay Ward?
Yes.
Okay, we're calling your case right now. This is Brown County case number 20 CT 612, State of Wisconsin versus Deontay Lee Ward. The state is here by Assistant District Attorney Aaron Linson. Attorney Imani Holly is present, and Mr. Ward is appearing by telephone. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Holly, what is our status here today?
Your Honor, I think the state intended to send me discovery, but I believe they sent the wrong thing. So I emailed them today, and hopefully we'll get a response soon with the correct documents. So at this point, I would be asking for another status date.
How about Monday, March 8th at 2 o'clock?
I'm scheduled for a jury trial that day.
Did I give you a date earlier on March 9th?
No.
No? Do you think you'd be available the afternoon on March 9th?
I'm available in the afternoon except for 3:45.
How about 2:30?
2:30 would work for me. Mr. Ward, does that work for you?
Yeah.
So Monday, or actually cross that off. Tuesday, March 9th at 2:30. Anything additional from the state?
No, Your Honor.
Bond continues, and that's all for today. Thank you.
Thank you.
William Matt, I see your name on there. We can call your case next with Attorney Schwakis.
Oh, I'm sorry.
Oh, and we have Attorney Stock? Or no, that's a different case.
Yeah, no, William Matt will be mine, Judge.
This is Brown County case number 20 CF 98, State of Wisconsin versus William John Matt Jr. The state is here by Assistant District Attorney Aaron Linson. Attorney Rick Schwakis is here. Mr. Matt is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. There is no one in the courtroom gallery. What is our status here today, Attorney Schwakis?
Yes, Your Honor. This is one where I had an expert report completed by Tim Kohler at the Center for Wellbeing. I actually called today to find out where that report is. I didn't see it here in my office, but I'll also allow the court to know. Yesterday was my first day back. I was out for 3 weeks. My first child was born, so I apologize for any delay that caused. But I'm just trying to figure out where that report is so I can get my motion filed.
Okay.
So I would ask for one more status just to track down that expert report so I can attach it to my motion.
How about for scheduling Monday, March 8th at 2 o'clock?
That works fine.
And then Mr. Matt, can you just acknowledge you heard that date and time, March 8th at 2 o'clock?
Yes, I have.
Anything additional from the state?
Your Honor, I guess I would just note for the record that if there isn't a motion filed by that, the state would be asking to move forward. This has been pending for some time at this state.
I understand that, Judge. I just need the expert's report. It's Tim Kohler. He did do the report. I'm just waiting to get it.
I'm not objecting to this date at this time. I'm just putting Attorney Schwakis on notice.
Sure, understood. The last thing I'll say, Judge, is my client brought up to me today as well when I spoke to him in preparation for this, that he needs to file his taxes at H&R Block. Right now he's on home arrest, so he's not allowed to leave there. Is there any way I can talk to the state to get a stipulation, or he can be allowed to go to H&R Block to file his taxes?
Isn't he married, if I recall?
He is.
I'm not.
Oh, I'm sorry. You're not married? Sorry, my apologies. He has a significant other, but they are not married.
Oh, so do they file jointly or not? Where she can do it?
I do have her on my tax returns.
Okay.
I'm going to defer to him, Judge. I don't know this answer, so I'll let him answer it.
You'll just have to file a motion on it, and then the state will review it, and they'll take a position, and then we'll go from there.
Will do, Your Honor. Thank you very much.
Anything additional from the state?
No, Your Honor.
Okay, then that's all for today on Mr. Matt's case. Thank you.
Thank you.
Dennis Flowers.
Hello.
Okay,
Hello.
yeah, we can hear you.
Okay.
We'll hear your cases right now. 20 CF 565, 20 CM 486, State of Wisconsin versus Dennis Coleman Flowers Jr. The state is here by Assistant District Attorney Aaron Linson. Attorney Jevin Giacone is appearing. His client, Mr. Flowers, is appearing by telephone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Giacone, what is our status here today?
Yes, Your Honor. I think we're getting closer to a resolution. The defendant is in the process, if not finished, with AODA treatment. The reason I bring that up is a Manitowoc case where that was contingent on. I think it would do him well for these cases as well. So upon that finishing, I believe we'll have everything resolved. It will be separate, it won't be consolidated. But want to go with that 326 one more time?
That's gonna be a pretty heavy burden for you, are you okay?
I like the trifecta. This time I won't schedule anything around it. I learned that the hard way, but yes.
Friday, March 26th at 11:30.
Sounds good.
Mr. Flowers, did you hear the date?
Yes, sir.
Friday, March 26th at 11:30.
Yep.
ADA Linson, anything additional from the state?
No, Your Honor.
Then bond continues, and that's all for today. Thank you.
All right, you have a good one. Thanks.
Corey Nelson. Corey Nelson.
Nelson. My client is in the hospital. I got a call from his mother today. He's hospitalized at the moment at Bellin.
Okay, we can call it right now then.
Yeah, he won't be appearing.
This is 19 CM 318, State of Wisconsin versus Corey Paul Nelson. The state is here by Assistant District Attorney Aaron Linson. Attorney Matthew Stock is here. Mr. Nelson does not appear. We're doing the hearing by video conference because of the public health emergency, and the courthouse is open to the public. There's no one in the courtroom. Attorney Stock, what is the status here today?
I got a call from my client's mother this morning stating that he was in the hospital at Bellin, and he's hospitalized. He's going to be unable to make the hearing.
ADA Linson, any comment from the state?
Your Honor, I would request a new date. I would just inquire from Attorney Stock if where this case is at.
I believe that I was just recently appointed here. Yeah, November. I just got discovery, I think, recently. So I need to just have a chance to talk with my client about it.
It looks like this is a case that went to diversion. It may have been brought back after being terminated.
That is correct. It looks like in July.
Is there any history of missing court that you know of, ADA Linson?
Reviewing now, I don't believe he's ever missed, and he's had appearances dating back to March of 2019. I don't think there's anything here that I would be concerned about at this time.
Okay, thank you.
And he was in good communication with me, Your Honor, throughout this process. I mean, his mom did give me a heads up that this is where, so.
We're scheduling, how about Monday, March 8th at 2:30?
That'll work.
And bonds continues, and that's all for today. Thank you.
Thank you. I know we had Metaxen earlier, Your Honor. I don't know if we could.
Oh,
she was
okay.
She was one of mine that was that we had. I think he sent a word out, but got it back.
Yes, let's call Jamie Metaxen right now. Dig it out. This is Brown County case numbers 20 CM 592, 20 CM 1370, 20 CM 1468. They're all State of Wisconsin versus Jamie Lynn Metaxen. The state is here by Assistant District Attorney Aaron Linson. Attorney Matthew Stock is appearing. Ms. Metaxen is now appearing. We did lose her video. It's back to a still photo. Okay, now she's back. Ms. Metaxen, can you unmute your device just to make sure you can hear us?
I can hear you.
Okay, great, thank you. What's the status of this case, Attorney Stock?
I had just received the new file, Your Honor. I just got discovery yesterday. I have not had a chance to go through it with Ms. Metaxen.
Okay. Ms. Metaxen, your case was scheduled for 2 o'clock. I don't recall exactly what time you signed on. But I don't think it was on time. Was there what was the issue, do you think?
I was trying to get on since 1:45 and I called branch 8 and they didn't give me the meeting number or some number was wrong or something. I don't know.
Okay.
Kept trying and trying, and then I called again, and she said I just have to keep trying, and I kept trying and trying and trying, and I still couldn't. And then I called her again, and then she said, "Well, you got a warrant." So then I called. No, then she got a hold of the attorney for me, and then that's when we all talked.
Okay. Okay. Well, I'm glad you continued to try logging on and it eventually was successful. But just be mindful of making the court appearances on time in the future. If we issued a bench warrant, it'll be quashed. I don't recall if we stayed the bench warrant or issued it immediately. Do either the lawyers remember?
I think it was issued immediately. I think it was a forthwith one.
Okay, so it'll be quashed if it was issued. Anything additional from the state before we schedule it?
No, Your Honor.
And we do need a current mailing address for Ms. Metaxen. Can you state your mailing address?
1250 1250 Doblin, DOBLON, Unit D, and that's in Green Bay, 54302.
Did you get it or do you need to repeat it? Okay, we got it. Attorney Stock, how about I give you the same time as I just gave you, Monday, March 8th at 2:30?
Good here.
Sorry, what was that?
Monday, March 8th at 2:30.
Thank you.
And then Ms. Metaxen, can you confirm that you heard the date and time?
I heard that. Thank you.
Bond continues, and then that's all for today. Thank you.
Thank you.
And then Justine Simmons, if you can unmute your device and turn the video on. We'll call your case next. This is Brown County case numbers 20 TR 4757 and 20 TR 6026. They're both Brown County versus Justine May Simmons. The state is here by Assistant District Attorney Aaron Linson. Ms. Simmons is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. The courthouse is open to the public. There's no one in the courtroom gallery. The two traffic offenses in this case are an operating while intoxicated first offense and a prohibited alcohol concentration first offense. ADA Linson, I'll go to you if there's been contact between the DA's office and Ms. Simmons on this case.
There has. Approximately 2 weeks ago, there was a telephone conference between, I believe, Ms. Simmons and Attorney Enley, who's the assigned prosecutor.
Okay. It was an offer conveyed? I don't need to know what it is, but was it?
It was.
Okay. Ms. Simmons, you're just clearing my throat for a second. Your options are, first, you can hire a lawyer if you want to. You can, in this case, you can hire a lawyer at any point. It would have to be at your own expense because these are non-criminal OWI first offense tickets. And if you want to continue representing yourself on the case, it sounds like you've already contacted the DA's office after waiving your right to an attorney. It sounds like the DA's office gave you an offer, so you can accept that offer, or you can take the case to trial if you wanted to. Have you thought about what you want to do in this case?
Yeah, I would like to take the offer.
Okay. The ADA Linson, why don't you state what the offer is then?
Sure, Your Honor. It's a plea to guilty or no contest to OWI first in the 20 TR 4757 file. We would be dismissing the 20 TR 6026 file, which is the PAC first. And then we would be recommending the left side guidelines for 0.226, specifically a $225 fine plus costs totaling $956, a $26.80 blood draw fee, 9-month revocation of the driver's license, retroactive and concurrent with any administrative suspension, 12 months of the ignition interlock device, and the AODA.
Okay. And Ms. Simmons, is that consistent with what your understanding is?
Yes.
Okay. It looks like this citation was issued after a traffic stop on August 26th, 2020 at about 11:09 p.m. in the village of Bellevue near the intersection of Hoffman Road and Development Drive. And the officer that issued the ticket was Sergeant Johnson of the Brown County Sheriff's Department. I don't have any other facts on the case though, ADA Linson, like the blood alcohol concentration.
I can briefly go over the facts if you'd like.
You just said it was 0.220, right?
There was a PBT of 0.255 and then a blood draw at 12:15 a.m. That came as a 0.226.
Okay.
And if you want, I can go through the basic facts.
It'd be good.
Yep.
Can you go through?
Oh,
basic
sure.
facts?
Yeah, you stated most of it. It occurred on the 26th at approximately 11:05. The officer observed a black SUV without its headlamps on. He noticed as the SUV turned onto Hoffman Road, it went into the oncoming lane about 3/4 of the vehicle before correcting into the correct lane. He then stopped the vehicle when told the reason for the stop. Ms. Simmons had a difficulty turning on the headlamps. Her movements were slow and jerky. He observed the odor of intoxicants and noticed the eyes were glossy. She had stated she was out for a friend's birthday, and when asked if she was drinking, she stated just a little bit, and then later admitted to having 2 beers at Induzzi's East. The roadside tests were administered, and then a preliminary breath test was administered. As I noticed, it was a 0.255. She did agree to the blood draw, and that's essentially the facts of the case. It was pretty quick.
Okay. So Ms. Simmons, do you agree that there are enough facts there to support a plea for OWI first as a non-criminal offense?
Yes.
Okay. And based on the facts that the state's provided, I will find there's a sufficient factual basis for the acceptance of a plea. And Ms. Simmons, you do have a right to a trial on this case, but you don't want to have a trial, is that correct?
Correct.
And you intend to plead no contest to the citation instead?
Yes.
Is anybody forcing you to make this plea?
No.
Are you doing this of your own free will?
Yes.
You understand that if I accept your no contest plea and I find you guilty, that this offense could be used to support a criminal offense as a second offense. Do you understand that?
Yes.
So each one of these OWI convictions, they all add up one on top of the other. Do you understand?
Yes.
And then if you did get a second offense in the future, there would be mandatory and minimum jail time on that offense. Do you understand?
Yes.
Okay. None of that applies to this offense because it's non-criminal though. The elements of operating without the elements of operating while under the influence of an intoxicant are first, that you operated a motor vehicle on a public highway, and second, that at the time you were operating the vehicle, you were under the influence of an intoxicant. Do you understand those are the elements of the offense?
Yes.
But if you plead no contest, that alleviates the burden on the state to prove that. Do you understand that?
Yes.
So then to the OWI first citation in 20 TR 4757, what is your plea?
No contest.
I'll accept the no contest plea. I'll find that it's been freely, voluntarily, intelligently, and knowingly made, that she understands the elements that we just went over. She understands the facts that ADA Linson put on the record, and she has an understanding for the rights that she is giving up. I will find her guilty of operating while intoxicated first offense as a non-criminal forfeiture and order the judgment of conviction into the record. And then what is the state asking for?
Your Honor, we would be moving to dismiss the 20 TR 6026, and then for the OWI first, we're recommending the left side guidelines. It's a $225 fine plus costs, totaling $956, $26.80 blood draw fee, 9-month revocation of driver's license, retroactive and concurrent with administrative suspension, 12-month ignition interlock device, and the AODA.
20 TR 6026 will be dismissed. And Ms. Simmons, did you want to make a comment on the disposition, the sentence?
No.
Okay. I will order the the penalty that's being recommended, a $225 fine for a total of $956. The blood draw fee of $26.80. So the financial penalty is significant, and hopefully that acts as a deterrent to reoffend in the future. 9 months revocation of driver's license, retroactive and concurrent, which will probably be a significant penalty for Ms. Simmons as well. 12 months of the ignition interlock device and an AODA assessment. So Ms. Simmons, you are very, very lucky that you live in this state. This is the only state in the entire country where a first offense for operating while intoxicated is a non-criminal offense. So if anybody ever asks you if you've been convicted of a crime, you can say no, because this was not a crime. If you get a second one, like I was saying, this one can be used to establish an OWI second offense, and that would be a crime. Okay, do you understand?
Yes.
Okay, so this really needs to be the end of it for you. If you don't want to have a crime on your record, if you have anything to drink, I would advise you not to drive at all, if you've had any alcohol at all. Do you have any questions about anything from today?
No.
Okay. The financial obligations will be due within 90 days or set up a payment plan. So if you haven't paid it in 90 days, don't ignore it. Make sure you set up a payment plan, okay?
Okay.
And then anything else from the state?
No, Your Honor.
Okay, then that closes these cases. I guess I should read the appeals, right? Because I guess you technically have the right to appeal. You're advised that you do have the right to seek post-conviction relief. You would have to hire an attorney at your own expense if you wanted to appeal or seek the post-conviction relief, though. And then that's all for today. Thank you.
Thank you.
And that's the last case of the day as well.
Your Honor, before you go,
yeah,
could I get the time for the William Matt hearing?